helping care for him, but it got to the point where she couldn't really handle it anymore, and Lenny needed to move into memory care. And that memory care facility is costing him $7,000 a month. So what he did back in 2019, when he moved into memory care, is he actually transferred his house worth $150,000 to his daughter as a gift and kind of to pay for the services that she provided him over the years. In addition to his house, he had $100,000 in his bank account, and that's the money that he used to pay for the memory care at a clip of $7,000 per month. So after about a year and a half, Lenny's money ran out. And at that time, Linda helped by applying for Medicaid on behalf of Lenny. Now, in that Medicaid application, they ask, have you given anything away over the past 5 years? And of course, Linda said, yes, Dad gave me his house as, as a gift, as a payment for helping him over the years. And because of that gift, because of that transfer, Medicaid is going to say, Lenny would be eligible for Medicaid, except that he transferred this house to his daughter. And what ends up happening is that Medicaid assesses a penalty period. Now, this penalty is just a time frame, and it's a time frame where Medicaid will not pay for that memory care bill until the penalty has expired. So Medicaid doesn't ask for money back. They don't make Linda give the house back. They can't make Linda pay. But they just say, for the next 15 months, you've got to come up with a way to pay that $7,000 a month bill to the memory care. So practically speaking, Linda's probably going to have to give the house back or sell the house to have cash to pay, because the memory care is not going to let Lenny stay there for free for 15 months. So this is kind of what goes wrong when you don't engage in Medicaid planning. And now on the next slide, we're going to talk about how we could have actually helped Lenny and Linda and come up with a much better result. So again, Lenny's only assets were his house worth $150,000, the bank account worth $100,000. If Lenny and Linda had come to me back in 2019, we still could gift the house to Linda. So that house can still transfer to Linda. But then with the remaining money, the $100,000 that Lenny had in the bank, rather than just paying that to the memory care facility each month, what we would do is we would take that $100,000 and we would use it to purchase a Medicaid compliant annuity. Now, this is a certain kind of annuity that Medicaid allows us to use where it's not considered gifted because Lenny still has access to it, but he's also going to be eligible for Medicaid. So all of this should have happened back in 2019. We gift the house to Linda, we set up the Medicaid annuity, and then at the same time, we apply for Medicaid. So Medicaid's still going to assess that 15-month penalty for giving the house to Linda, but this time we have a way to pay through that 15-month penalty. Because we have that Medicaid annuity where we put our $100,000 from the bank into it, that annuity is going to pay Lenny $7,000 a month for 15 months. So that's how he's going to pay for the memory care. Once those annuity payments stop, at the same time, that 15-month penalty will be over and Lenny will be eligible for Medicaid, and Medicaid's going to start picking up the bill. So we still have the same thing. Linda's getting the house worth $150,000. Lenny is still paying $100,000 to the memory care facility. But once that's done, he's eligible for Medicaid. We don't have this gap of 15 months where we have to try and figure out how we're going to pay for it. So that's the difference between, kind of doing something on your own and not realizing there's an issue versus planning with our office where we can get, the same end result and we don't have to worry about the penalty. Okay, we're going to move on to our second example. And in this example, we have a person who doesn't have a whole lot of assets left, and they might not think they need Medicaid planning. So in this example, we have daughter Kathy, and she's going to move her mom Sue into an assisted living facility. Sue will be eligible for Medicaid in less than 5 months because she doesn't have all that much left in her assets. Her only asset is a bank account worth $30,000. So her daughter, Kathy, doesn't think it's worthwhile to do any kind of Medicaid planning because she's going to be eligible in, less than half a year. But we could still do some Medicaid planning. We could help the family out. So one thing we could do is pre-plan and prepay for a funeral and burial. By doing that, we ensure that it's taken care of, and the kids aren't going to have to pay for that out of their own pocket. So that might be $10,000 that we spend on a funeral. So we still have $20,000 left in Sue's bank account. What we could potentially do with that is put it into a special kind of trust. Again, this is a trust that is allowed under Medicaid rules. By setting up this trust, it's not seen as giving it away. So there's no penalty period for moving the money into the trust. And the trust money can still be used for Sue's needs. So once we move the money into this kind of trust, Sue would be eligible for Medicaid right away. So Medicaid's going to pay the bill at the assisted living, but they're not going to pay for other things that Sue might need over the rest of her life. So that might be new clothing. It might be dental care that's not covered by her insurance. It might be, she needs a new lift chair when she moves into the assisted living because she can't get up on her own anymore. Her TV breaks down and she needs a new TV. All of those kinds of expenses to keep her comfortable can be paid out of that trust money while Medicaid is paying the major bills. Another way we've seen this money used is to pay for a private room for Sue. And the difference there is once you go on Medicaid, Medicaid will always, or the facility will always make you move into a shared room. And so in order to keep Sue more comfortable and give her a little more privacy, we can use that money to pay the difference between a shared room and a private room. So it's used to make Sue's life more comfortable at the end of her life. Okay, now we're going to move on to example 3. In example 3, we've got a married couple. So this married couple is husband Bill and his wife Mary. Mary needs nursing home care, and the nursing home is going to cost over $10,000 a month. So Bill comes in and he's really worried that, at $10,000 a month, it's not going to take all that long for them to go through all of their assets. So he comes in and he's worried and he wants to know what he can do to protect money. So we've got Bill and Mary's assets listed there. Just to go through those, they have a joint bank account worth $80,000. They've got a savings account that's just in Bill's name. That's worth $20,000. They've got a house. They own that outright, no mortgage on it, $250,000. They each have a life insurance policy in their name. The cash value on the life insurance is $25,000 each, and the death benefit when they pass away will be $75,000 for each of them. Bill has an IRA worth $150,000, and Mary has an IRA worth $50,000. So would they be eligible for Medicaid? The answer is no. And if we go to the next slide, we'll see for a married couple, you see what they're allowed to keep there. Between $50,000 and $130,000. And the way that Medicaid figures out what you're allowed to keep is they take all of the countable assets and they divide by 2, and it has to be within that range. Bill and Mary can keep their car, their house, and all of their household furnishings. Small life insurance policies worth less than $1,500. Prepaid burial and funeral. So that was one way that we spent money in the last example. They let you prepay your funeral. And then the spouse who's not going into a facility. So in this example, that would be Bill. Bill's retirement accounts are, Bill is allowed to keep those. So now if we go back to their assets on the next slide, what are going to be considered the countable assets? The joint bank account will be counted. The savings account, even though that's just in Bill's name, they still will count that. The house will not be counted. That's exempt. Those 2 life insurance policies, again, even though one is in Bill's name, one is in Mary's name, they're counting both of those. And what they count is the cash value, not the death benefit. So that's $50,000 worth of cash value. Bill's IRA is exempt, but Mary's is not. So we add up the countable assets, and because I like easy math, those countable assets add up to $200,000. And then what Medicaid will do is they'll cut that in half. So because they have 200,000 in countable assets, Bill and Mary need to get down to 100,000 in countable assets in order to be eligible for Medicaid. Next slide, please. So they've got to spend that $100,000. So, Bill is relieved to find out that he gets to keep his IRA. They're not going to take the house, but that's not as bad as he thought, but it still would be nice if he got to keep the money to live on, rather than spending it on the nursing home. So Medicaid has provided a tool for us to use in order to temporarily move that $100,000 out of their names so that Mary can become eligible. So what we could do in this example is that we could cash out Mary's IRA. We could also take an additional $50,000 out of the bank account. So we've got $100,000. And what we're going to do with that $100,000 is we're going to loan it to their son, Ben. As long as the loan meets the Medicaid requirements, Medicaid will be instantly eligible. Mary will be instantly eligible for Medicaid. And then once Mary is on Medicaid, Ben is going to repay that loan to his father, Bill. So Bill still has all of the 200,000 in countable assets to live on, and Mary is eligible for Medicaid. And I've got one last example. So we're going to move on to example number 4. This is an example of what we can do to protect assets before somebody needs to go into the assisted living or the nursing home. So in this example, we've got Dorothy, who is only 70 years old, and she's in good health right now. She's not looking at nursing home care for herself, but she just watched her neighbor go through this process, and all of the neighbor's money was spent on the nursing home. So she wants to make sure that that doesn't happen to her. She wants to make sure some of her money can be protected for the kids so that the kids get an inheritance and not everything goes to the nursing home. So when we look at Dorothy's assets, we've got bank accounts worth $100,000. We've got investment accounts or brokerage accounts worth $100,000. And then she's also got some life insurance worth $50,000. So in Dorothy's situation, we can move some of her assets into an irrevocable trust. This type of trust is different than the trust I talked about in example 2 with Sue. And it's also different than a trust you might have set up by our office, a revocable living trust. Just another type of trust. It's an irrevocable trust. And with this trust, we can move assets into that trust, and then we have to wait 5 years before those assets are protected. And so this is a really good option when people are worried about the cost of long-term care, but they're still in good health. They're not thinking they're going to need to move into any kind of facility in the next 5 years. So with Dorothy, we can take half of what she has in the bank, half of what she has in the brokerage account, and that life insurance, and we move it into the irrevocable trust. She keeps half of what she has in the bank, half of her brokerage account to live on. And as long as she waits at least 5 years before applying for Medicaid, everything that we moved into the irrevocable trust is going to be completely protected for her. So just another example of how we can try and protect assets for the family. And that's it. Those are all of my examples. So thank you so much for attending, and I'm going to send it back to Mark now.
So the next thing on our program is going to be a video done by Amanda McCormack on a tax law update. But I should say, I forgot to tell all of you that this program is being recorded, so that if you feel like you've missed something or want to review it, it's going to be on our YouTube channel, just as last year's program was in segments. So let's go ahead and proceed with the video by Amanda.
Hello and welcome to the tax update portion of the Angermeier and Rogers annual estate planning update for our clients. I'm attorney Amanda McCormack. Some of you already are familiar with me, but I typically handle all of the tax return reporting for our trusts and estates in our office, and I do quite a bit of work with our high net worth clients as well as on the post-death side. Today, we're going to be just talking about the taxes that impact us from an estate and gift tax perspective. There have been substantial changes in some income tax laws due to the pandemic, most of them positive relief type provisions. So if you are interested in finding out about how maybe that legislation might impact your 2021 income taxes, I would recommend that you speak with your financial planner or CPA or accountant, and they can help walk you through those changes. Today, we're going to really be focused on estate and gift taxes, what changes are on the horizon, and how that might impact you or maybe give you reason to come in and have an update or review with one of the attorneys at our office. As you may have heard in the news, the Democrats have been very busy trying to get some proposals into law. We have just passed the bipartisan infrastructure bill, which was a big deal, and they have been negotiating the Build Back Better Act that President Biden would like to see get moved into law. And that has already passed the House, and now it is going to the Senate. What you may not know is there was actually quite a bit of back and forth in the law and in the discussions since September of provisions that would actually have not just changed the estate tax landscape a little bit, but would have actually fundamentally changed some of the tools we use in estate planning with the use of irrevocable trust, typically used to do high net worth planning. Some of the planning, though, Medicaid type planning, uses the same type of tax trusts. They are called grantor trusts. And that was something that was going to be revamped under the provisions that were advanced by the House Ways and Means Committee back in September. So we've been on quite a bit of a roller coaster. Had those changes come into play, we would have had to bring in quite a few of our clients to review any of the irrevocable type trusts that we set up to see if we needed to modify what's referred to as the grantor trust status of those trusts. The other change that was going to impact our clients potentially was the Ways and Means Committee proposed that they accelerate the reduction of the estate tax exemption amount, the lifetime amount you can give without incurring estate tax or gift tax. And they wanted to have that dropped back to about $6 million per person. Right now, it is $11.7 million per person. So the estate and gift taxes don't impact nearly as many people as they used to. Some of you have been around long enough to know that there was a time when the exemption was only $675,000, 1 million, a couple of million. So we've been paying close attention to this exemption rate because it is at a very high level and seems to be low-hanging fruit for something that they can reverse and move down to a lower level in order to generate some more revenue for the government. If they would have put that provision into place, it was going to go into effect January 1st. If they were going to revamp all of the grantor trust rules, those were going to go into effect on enactment, which meant that there was the possibility that some pretty drastic tax law changes were going to happen before the end of the year, and we had a very limited planning window to get irrevocable trusts updated for a variety of reasons. Luckily, they pulled both of those sections out of the current Build Back Better law, and so we aren't under the gun to make those types of changes right now. So what we're looking at for 2021, the lifetime exemption amount continues to be 11.7. $1 million per person, so just over 23 million for a married couple. And in 2022, right now, the exemption amount is just over $12 million per person, so 24 million for a married couple. So we still have plenty of time to look at these exemptions, and some of you are thinking, well, I'm not ever going to have to worry about that, and that's great. One thing to keep in mind is that the exemptions are already scheduled to revert back to about 6 million per person beginning January 1st, 2026. So even if nothing else is done, we know that baked into the law there is an exemption reduction coming in the future. So generally, if you are a single person and you have maybe between $5 and $6 million of wealth today, or you're a married couple and you have between maybe 10 and 12 million today, I would recommend maybe coming in and just getting an estate planning checkup done, making sure that all of your documents are up to date so that we can maximize the use of the exemptions, make sure that your plan accommodates the type of structure that we would need in the future. So if that exemption does drop back to that 6 million, that we've still got you covered one way or the other. Otherwise, from an estate planning perspective, we don't really have a tax reason where there's a crisis planning, any crisis planning that needs to be done at this time. We have recommended for our very high net worth clients that we do get in and get some of this planning done sooner than later, and that is because it is always better to use exemption while we have it. The IRS has already said that they will not be coming back after or clawing back gifts we make with higher exemption amounts, so that's good news. And even pertaining to the grantor trust changes that were recommended, if for some reason a future bill brings those back and they do change those rules pertaining to grantor trust, then the trust that we have already created and have funded, they plan to grandfather those that were done under old law. Both of those are good news. So from the standpoint of if you have an irrevocable trust that was created and somewhere in that trust, we would have maybe had a section that says grantor trust provisions. If you have a trust like that, it might be a good idea to just come in and have us take a look at it. And what we would specifically be looking at is making sure that there was a way that if we needed to turn off that grantor trust status so that we wouldn't disrupt any planning that was in place. We just want to make sure that those trusts are outfitted with as many tools as possible to give us as much flexibility as possible as we move forward with the possibility of changes down the road. Other than that, most often people ask at this time of year, okay, well, what is the annual exclusion for gifting? What can we give away where we don't even have to file a gift tax return? And that amount is $15,000 per person. So if you're a married couple, you can give your favorite child $30,000 between the two of you and not have to pay any gift tax. Next year, there's an inflation adjustment. And so for 2022, that is going to go to $16,000 per person. And then again, for those of you that might be sending kids to college or have medical bills that you might be paying for your adult children, you can still have unlimited gifting exemption for directly paid medical or tuition expenses. So those really are the main items of the tax update for this year. We're going to be keeping our finger on the pulse of what's going on in Washington, as there may be some bigger changes that come down as they continue to navigate forward and make various changes to programs or adding new programs. Tax changes always seem to go hand in hand because that's the way that they pay for these programs. But as of this year, unless you are wanting to get some planning done and use your exemption amount because you have millions of dollars that we need to move around right now. This year, you're going to be just fine, not worrying about making those substantial transfers or getting the gifting done before the end of the year. But again, it's always a good idea, if you have existing irrevocable trusts of any kind, to contact the attorney that helped you with that, and maybe come in and let us just look at it, make sure we have all of the current modern tools to deal with what we see might be coming down the pike in the future. In the meantime, we hope that you appreciated the information you were able to gain today, not just from the tax update, but from the other segments as well. And I wish you a very, very happy holiday season.
So Vincent and I are now going to do a presentation on what successor trustees should know. This is an annual part of our program. And so I'm going to turn it over to Vince to start off with describing the value of using a trust in estate planning.
So I'm Vince Angermeier, and as the topic of the presentation suggests, this is mostly for trustees. And so we're going to run through a lot of the basics of trusts and why you should have them. And I understand that many of you already do have them, but this is important information to communicate to the people who wind up being responsible for handling your affairs. And that can begin earlier than you think, which is where we talk about incapacity planning. That's an aspect of trusts that people don't think about as much because trusts are mostly associated with post-death planning. And for a lot of people, even when compared with death, thinking about their own incapacity might even be a harder topic to bring to mind and to plan around. It involves more gradual loss of an ability to handle responsibilities, placing more and more trust in people around you, dealing with very difficult situations. But trusts can make that easier. They play a role in making sure that the people you want to be responsible know that they're the people who are responsible, and that others know who's making the decisions and who you want to be making the decisions. And then you can give more guidance to those people, specific decisions about end-of-life planning, about how expenses would be paid for, what kind of procedures doctors can undertake on your behalf, but not necessarily with your conscious consent. All of those decisions and aspects of end-of-life care are made a lot simpler by a trust. And it makes it all the more important to talk with your successor trustees about what it is you want them to do. They should also know the basics of post-death trust planning, because they're different from successor planning, because the number one thing is that trusts are a way to avoid probate. You avoid the delay that goes in with the probate procedure and also the expenses. And really, if there were no other benefits to trusts, just avoiding probate alone would probably be enough to justify having a trust for most people. But there are other angles. And so certainly the more money you have and the more exposure to estate taxes you have, trusts have long been a primary method for limiting your exposure and often bringing your exposure down to zero. And also trusts offer flexibility because the estate tax laws might change again, and the exclusion amount might come down again and bring more people within that umbrella. And a well-designed trust creates the flexibility needed to adapt to those kinds of changes. It also helps you anticipate scenarios that actually are unanticipatable, like if your beneficiaries start running into large expenses, if they face a costly divorce or liability for a car accident or malpractice or something like that. Trusts provide a great degree of asset protection, which is very useful in those situations. And really the primary benefit is that it helps make your wishes follow through, even when unfortunate things happen long after your death. And with that, I'll move back to Mark.
So we're going to now talk about what happens when you are stepping up as the successor trustee because someone in the family has passed away. So the successor trustee is to wind up the affairs of the deceased trust maker, and there's going to be a little bit of a list that we're going to go through of things that are going to happen. I should add that most of you have a red trust book. It's very important if you're the parents that your successor trustees know where that red book is kept. so that they can quickly find the documentation for the estate plan. And that red book happens to have in it a section called emergency. It's in red, and it will have some of the information that we're about to talk through right now. So we need to prepare an inventory of the assets and debts that the deceased trust maker had on the date of his or her death. And that's something that we compose with the assistance of the successor trustee, giving us the account statements and so forth. We will also assist in filing claims for assets like annuities, IRAs, 401ks, and the like. And so we need to make sure that those claims are put in, and that we also handle the valid debts, real estate taxes and mortgages, credit card debt, the expenses of last illness. All of those things need to be paid before we distribute the estate. And then we pay administrative expenses, fancy terms for court costs, attorney's fees, and trustees' fees, and the fees of valuations. Sometimes we will do an appraisal of a piece of real estate to get its fair market value. So next slide. The successor trustee also will be responsible for two aspects of tax reporting on the income tax side. The first is the final personal tax return for the decedent. That's reported on the Form 1040. And we report income from January 1 through the date of death. From the date of death forward, we can no longer use the deceased trust maker's social security number as the tax ID number of the trust. And so we have to get a new tax ID number, and we report the income that comes in on the decedent's assets from the date of death to the day that we're done distributing the assets on a Form 1041. And that's a tax return our firm will do. And in some cases, wealthier clients may need to file a gift tax return, an estate tax return, and a generation skipping tax return. Those are done on Forms 709 and 706. There will not be a quiz after this program, but we just want you to know that there can be a variety of tax work that has to be done. The successor trustee is responsible for having an accounting of the administration. That is a listing of all dollars in and dollars out of the estate from the date of death going forward, so that the beneficiaries can see how we arrived at the number of assets that are being distributed to them. And then we do the distribution of the remaining assets to the beneficiaries. We work with you to do that. And we will, if there are trusts that are created for the beneficiaries, we'll set those up, get the tax ID number and the paperwork that's needed, so that assets passing to a trust share instead of to the beneficiary directly can go into an account in the name of the trust. Next slide. So another responsibility for the successor trustee is ordinarily to retain a trust settlement attorney. We do that kind of work. We hope you'll retain us, but you can go to any attorney that regularly does this kind of work. What that attorney is going to help with, besides all the other things that we just went through, is understanding and applying the meaning of the trust to each beneficiary. Sometimes it will appear to you as successor trustee that the trust is written in good old-fashioned plain English, but sometimes the terms will not be quite that easy to understand, and you'll need the assistance of a skilled attorney to know what things actually mean. We also need to provide information to the beneficiaries during the course of the administration, so that they know what's about to happen, how long it's going to take, what kind of information they'll be receiving. And then last, we want to figure out if a trust protector should be appointed. At the point of the death of a trust maker, the trust has become irrevocable. So the revocable trust changes into an irrevocable trust. And the individual that drafted the trust is either deceased or no longer in a position to write any changes to the trust. Here's what we might want to do with that trust protector. So next slide. So the person who is going to be the trust protector It's going to be a person appointed by you directly in your trust, but most often the language in your trust is going to say that the trust protector is appointed by the attorney for the acting trustee. And so for those of you who are watching who are our clients, that's you. You're the trustee of your own trust. We're your attorneys. So we have the power to appoint a trust protector. When a death occurs, your son or daughter might be the successor trustee. It might be your brother, and they will work with an attorney. Often it is not us. Sometimes it is not us. And so that individual that's been hired by your son or daughter has the power to appoint a trust protector. Now, what can the trust protector do? Big picture, we can make modifications of a trust as long as it's consistent with your intent. So the idea that we could just change anything would not be correct. We can do basically what a court would be permitted to do. So most of you are going to have trust protector language in your trust already. If your trust was written after 2000, in or after 2007, and even if there is no trust protector in your trust, Wisconsin state law changed in 2014 and allows us to appoint a trust protector. Next slide. So what do we want our trust protector to do? Well, the joke around our office is we call the trust protector a trust fixer. And so we fix tax planning that no longer makes sense. So we try in these programs to encourage you who have not been in for 10 years or so to come in to see if your tax planning needs to be adjusted, because the estate tax exemption has gone up to such a high number that you're probably not affected by the estate tax. And so if you've got a family trust inside your trust that has to be funded when one of the two spouses dies, that probably won't make sense. And so the trust protector can make an adjustment so that we can simplify the functioning of the trust, and we don't have to create or fund that family trust. And that can save thousands of dollars in attorney's fees. Sometimes the tax adjusting we do has to do with your kids or your spouse getting a thing called a step up in basis. The family trust is famous for not getting a step up in basis. What that means is if you've got assets there that have some sort of, there is an adjustment in basis that happens at death, and we don't want to pass that up. So we put language in the trust to make sure that happens. And then we also want to make sure that unnecessary income tax is not paid on IRAs payable to the trust. And we'll talk a little bit more about that later. Next slide. Another thing that trust protector might do is to make sure that the asset protection that we've provided for a child who has a trust will continue. If we end up in a state that says that there's no asset protection unless there are two trustees instead of just one, then that's an adjustment that we can make. We also want to make sure that the beneficiary's inheritance is protected from a Medicaid spend down. Most trusts for kids are protected in that way, but again, state law can vary from state to state, and we may want to make an adjustment. Last, we may want to fix who the trustee is and what the qualifications for the trustee are. And again, this happens because time goes by from the day that we set the plan up. We may have set up the plan when your kids were young adults and their children were just infants or toddlers. Now 20 years have gone by, the grandkids have grown up, and we could imagine who could be an appropriate trustee for the grandchild in case your child has passed away. So all of these things can be adjusted using a trust protector. Next slide. Now what we're going to do is move on and start talking about the fiduciary duties that a trustee owes to the beneficiaries. And Vince will start off with this.
So as Mark was discussing, there's a lot of work we do with trustees to make their lives easier and to help things go smoothly. But they'll always have some portions of that process that are their responsibility to carry out. And that includes judgment calls that we can't make for them. And there are some overarching responsibilities they have in how they carry out their duties. They're very broad in many ways. So they have to act in good faith. They're fiduciaries. It just comes with the responsibility and trust of being a trustee. When it comes to financial decisions, they often have to manage money, and they're managing money on behalf of not just themselves, but other beneficiaries who are counting on them to manage the money in a way that ensures the money will still be there when it's needed. And that's also carrying out the basic principle of carrying out the trust maker's wishes, your wishes, which also would usually involve the money being in a stable, responsible investment that doesn't carry a high risk of being wiped out. And so those are two of the broader responsibilities: always act in good faith, make reasonable investments with cash. Now, as I mentioned earlier, one of the benefits of having a trust is being able, and we can move to the next slide. One of the benefits of having a trust is being able to leave specific instructions for the trustee to follow. And so while they might have a lot of wiggle room when it comes to interpreting terms like good faith or responsible investments, the responsibilities are very specific when specific responsibilities are placed on them by the trust documents. And that's where we would help to a fair degree, because there's fewer judgment calls to make. It's more checking boxes through a list and making sure that the nuts and bolts of the trust agreement are carried out and money goes to who it's supposed to go to and is used for the purposes it's supposed to be used for. And then next slide. And that brings us to the major limitation, because in terms of being protected by good faith, one of the easiest ways to be shown to be not acting in good faith is when money is managed by the trustee in a way that primarily benefits the trustee to the exclusion of others. And one of the number one ways to break that rule unintentionally is to commingle funds. And that's why our law firm, we handle money in trust for clients, but we do not commingle the funds, because that's really the number one way that attorneys get in trouble with ethical bodies and with clients, is by commingling funds and losing track of which money is, their money and which money is money that they're holding on behalf of other people. And so that's the key thing that we work with trustees to avoid, is to avoid being accused of mishandling funds and to leave the boundaries of good faith. Next slide, Inspector Mark.
All right. So those of you who are serving as successor trustees are wondering, am I going to get paid for all of this work? And the answer is yes. You're able to charge a reasonable fee for your services unless the trust says differently. And I can tell you, it's hard for me to remember a trust that I've done in the last few years that did not allow a payment of trustees' fees. But you have to remember that the fees that you receive are reportable on your income tax return. They're taxable income. And then disputes over fees can be decided by court. And you don't have to take a fee if you don't want to. And the people that typically will not take a fee, if it's a surviving spouse, they won't take a fee. Sometimes if it's they're just two beneficiaries and both of you are serving as trustees, you may decline to take a fee because you're going to get the money anyway, tax-free as a distribution instead of having to pay income tax on it. Slide. So do you have to do all this by yourself? And the answer is a resounding no. This is really not meant to be a do-it-yourself project. You're going to rely primarily on the estate planning attorney that assists you, but others will be there to help, including the family's CPA or tax preparer. We often have that individual do that final personal 1040 with the information that we provide to that person. Your financial advisor will help consolidate assets, liquidate things. Same thing with your insurance professional, and a care manager may be involved as well if we've got an individual who is impaired. So the reasonable cost of these services are paid from the trust assets, not from your personal assets. Sometimes at the beginning of an administration, there's no way to get at some of the money without some documentation. And you may advance funds, and that's perfectly okay. And then you'll be reimbursed as soon as we can. The attorney's fees for the work generally will range from about 1.5%, and that's going to save at least 1% compared with a probate. So if you save 1% on $1 million estate, you just save $10,000 in fees. So next slide. Now we're going to move on to our colleague Roman Wojnacki, who is going to do a presentation on when is it time to contact our law firm for some help.
So generally, there's 3 reasons that clients should contact us. Changes in your situation, changes in the law, and changes in the way we plan. And I'm going to go through each of these 3 reasons for you. Next slide. So changes in your situation, it's real important that you tell us about these, because unless we read about it in the paper, we're not going to know that some of these things have happened. So the main changes in your situation that we want to focus on are health status. It could be your health status or a family member. Maybe someone you named as a successor trustee would no longer be able to serve in that capacity. If you move to a different state or you're planning to move, that would be another reason. Retirement. At retirement, many times you realign your assets, and that realignment may impact the funding of your trust and the naming of beneficiaries. So we would like to be consulted then. Marriages and divorces, we have a very, very good record of our clients not getting divorced, but this could impact your children and grandchildren beneficiaries that maybe you want to let us know this has occurred. Sometimes we change names and plans, but legally that's not necessary. Births and deaths. Deaths is one occurrence that surprises us a few times a year, where we will have done planning for a husband and wife in a joint trust, and then we'll get a call from a child saying that both parents have passed away. We can normally take care of that situation without too much difficulty, but it's important for us to know if you have a joint trust, even if there's not a lot of work that needs to be done when the first spouse dies, that we really should be consulted when that happens. Occasionally, we need to be contacted because someone has fallen in disfavor with you and the plan needs to be adjusted for that reason. And on the happier side, maybe an estrangement has been repaired, and now someone that may have been left out of a plan may now be included again in the future. If you receive a large inheritance or win the lottery, then we may have to do some tax planning that you previously didn't need. For everyone, we like to see you 2 to 5 years. And usually as you get older and past retirement, the time is usually sooner rather than later. Families that are still younger can usually wait a little longer for a review unless one of those changes in situations that I've talked about occurred. But as you get older, it makes more sense to get in contact with us on a more frequent basis. And then finally, when children grow up or grandchildren grow up, it can be helpful to review your plan, because when you initially did your plan, your children may have been too young to serve as a trustee or to serve as a healthcare agent. But as they get older, now they can serve in those roles. So maybe they're going to replace a sibling or even a parent. Next slide. So changes in the law. We heard about tax law changes and how we can help you to decipher the impact of those changes upon your plan. Asset protection is a way that we can make sure that your hard-earned estate, when it's received by a beneficiary, can be protected. there have been changes in asset protection that I'm going to talk a little bit about next, how they impact the way we do planning. Medicaid planning, we want to make sure that the documents you have in place allow Stacy and Mark, if we have to do Medicaid planning, to have all the tools they need in your existing plan to go on and do advanced planning, or if we have to do some type of crisis planning, we have the tools to do that. And then also digital property is a good example of something that when I started doing estate planning over 20 years ago, we didn't have to address that in the plans, but now it's something that Wisconsin law specifically has addressed in statutes, and we want to make sure that we include any provisions that impact digital property in your planning. Next slide. So the way that we plan sometimes changes. We get smarter, the law changes, and we need to adapt to that. We get feedback from our clients that they may have had issues with the way a document was drafted, so we may rethink the way we do that. One example again is digital assets. We add language about that now. Another change in the way we plan involves strategies for beneficiary controlled trusts. And those are the trusts where you allow the beneficiary to be their own trustee. Prior to 2015, we used to need to team a beneficiary with another co-trustee in order to have the best asset protection. Now for your beneficiaries, at least living in Wisconsin, that's no longer necessary. So we can modify plans to allow beneficiaries to be their own sole trustee without having to team them up. The next bullet point talks about the broader use of disclaimer trusts for married clients. Mark talked about how a trust protector can step in and save some of the administrative costs after the first death, but it's much better if you can come in, meet with us, and be consulted on the way you would want your plan to work. The reason we can save administrative costs at the first death is we don't have to do as extensive tax planning. As Amanda discussed, the estate tax credit is extremely high, so very few clients now need to use a family trust in order to do tax planning. That may change if the exemption is reduced, but for now, we're able to use a disclaimer trust, which means that on the first death, the surviving spouse can pretty much carry on business as usual without very many administrative costs. And then finally, we can get a step up in basis, which is a capital gain planning strategy, by adding a provision to a family trust if that is something that is still a good planning strategy for you. I did mention there that we are seldom using family trusts now, but in the case that we were to use them, we want to make sure that your children or you would get a step up in basis and avoid unnecessary capital gains. We can also apply that to trust shares if your children have their shares in trust and then they pass away. We can try to maintain a step up in basis for them. Next slide. So the way to initiate a review is to give us a phone call. You can send an email. We do want to hear from you. And if you do contact us and don't hear from us, please get back in touch with us, because sometimes it doesn't happen too often, but if we have a message that we don't get back to in time, we want you to remind us, because we definitely want to be in touch with you and answer the questions you may have. Next slide. So the type of review you could have, it could be simple as a phone call. As Mark said, we are still using COVID-related procedures for meetings, so you may feel more comfortable with a video conference. And then also we can have in-person meetings at one of our 3 locations, or if medically necessary, we can come out and visit you. The best thing that you should keep in mind is it does not cost anything for you to have a review. The purpose of the review is to catch up with you, talk over how well your existing plan would work due to the change in circumstances. And if no changes are necessary, then there's no charge for the review. If we do need if we do recommend changes, then our policy is, again, we try to work from a fixed fee basis. We would tell you exactly how much the cost of the work would be, and then you can decide whether or not you want to make those changes. Next slide. So there we go, Mark. You can take it from here and wrap up the program. Thank you for attending.
All right, so time to wrap up. Okay, we're going to go ahead and finish up the program. I'll give you a quick review of our services. I'm hoping that you're wondering if you need a review, and if you're on the fence, I would say yes, give us a call. We'll see what we can do to help you out. There will be a digital survey sent out to all of you that send us your email addresses. And that would be one place you could ask for a review if you wanted to. If you are new to us and you're getting the idea that maybe you should get an estate plan done, you'd also be able to use that digital survey. And so when in doubt, please give us a call. Let's take a look at the services our firm offers. We offer work in 4 different areas, but they're all related. One is estate planning. That would be the basics, setting up a will or a trust, powers of attorney for healthcare and finances, marital property agreements, business succession planning, and the like. The second area is elder law, and that is assisting individuals to become eligible for Medicaid so that we can save some resources for the family, including pre-planning with irrevocable trusts and other asset protection planning tools. Then we do also trust administrations and estates, including probate, and the tax work that goes with that, and assist with claims for insurance, annuities, and the like. And the last area is we do some tax planning using life insurance trusts. This is more advanced work, IRA trusts, and charitable planning options. So please remember us if you need help. I did want to touch on one particular issue that continues to be a good reason to come in for a review, and that is whether you have what's called an eligible designated beneficiary for your IRA. That would be a minor child, a disabled individual who has a finding of disability from the Social Security Administration. And some of you don't have kids, and you're leaving your estate to brothers and sisters, nephews and nieces. And if the beneficiary is not more than 10 years younger than you, or in fact older than you, like a brother and sister would be, they can use life expectancy instead of being forced to take the money out over a 10-year time period. Some of you need to have your trust adjusted to be a thing called a conduit trust for those types of beneficiaries, the eligible designated beneficiary. And so you might want to come in, and sometimes just a phone call can get you an answer for that. And then sometimes we need to adjust the beneficiary designation. Next slide. So we're still in 3 locations, and we reminded everybody that we moved our Milwaukee location just a block south on Milwaukee Street to 759 North Milwaukee Street, from which this program is originating. Our Waukesha office and Cedarburg office are still operational. The Waukesha office is off of Highway 164 in Waukesha, and the Cedarburg location is on Highway 60 near is it the Four Corners or the Five Corners, Stacy?
5 corners.
5 corners. So now let's go to the question and answers segment. There is a button at the bottom of your screen that says Q&A. And if you send us a question, you'll type it out. Joe will read it to me and I'll repeat it. And then somebody in the room, Stacy or me or Roman, will attempt an answer. What have you got, Joe?
So our first question comes from Marie Guzman. She asks, who values the collections of a deceased trust maker, i.e. jewelry or antiques?
So the first question asks about how jewelry and antiques and the like get valued when somebody passes away. We typically will hire or get an appraisal from a professional. So on the jewelry side, most jewelry stores have qualified appraisals, but for collections, sometimes we have to do some research on the internet to find somebody who is qualified to value a collection like that. Now, I should add, while we're waiting for the next question, that we have set a question and answer session for December 29th. As we did last year, it'll start at 10 in the morning on Zoom. And there, when people sign up for that, we ask them to view one or more of the videos that we've made to see if they have questions about those. Is there any other questions, Joe?
Yes, we have a question from Kathy who says, my daughter, the beneficiary, her last name has changed. What needs to be done?
It depends. Usually that will not cause a significant issue if it doesn't get changed. It's usually marriage or divorce that causes that to happen. But if we have other things that we want to change in an estate plan, we will then fix that last name and say that this person was formerly known as, so that both possible names are going to show up. But for sometimes we can handle it simply by just having a simple amendment that says that my daughter's last name has changed from Smith to Jones, and then we leave the name as is in other documents like healthcare power of attorney, financial power of attorney, and we don't worry a great deal about difficulty because we can usually step around those difficulties. Stacy, did you have anything to add to that? Okay, all right.
Currently, there are no more questions.
All right. Well, you've shown mercy on us. Thank you all for coming today. We very much enjoyed this. We have no idea how you reacted to our stuff, but we hope it was enjoyable and informative. So again, if you're interested in more follow-up questions, please join the December 29th session. Sign up for that. We had quite a good crowd last time, and we had about an hour's worth of questions, as I recollect. So with that, we will sign off.
Just a reminder, the link to the survey has been put in the chat room.
It's already there. The link to the survey is already in the chat room. And I think we will be sending a follow-up email as well that will have that link. Yeah, thank you so much for your time and attention.